Good morning. Thank you so much for inviting me here. I've already learned a tremendous amount from listening to the wonderful first panel, and of course also from listening to Steve. My role on the panel is to provide the background, the legal principles, and meaning of the Establishment Clause. And frankly, that is quite a difficult task. The 16 words that begin the First Amendment to the United States Constitution: Congress shall make no law respecting an establishment of religion, are among the most controversial and widely debated phrases in the Constitution. And as a professor of constitutional law, I can say that with some authority. That still remains really probably some of the most heated and controversial classes that I teach. Few provisions of the Constitution has engendered greater disagreement than the Establishment Clause over 200 years. And I think it's safe to say that virtually no provision of the Constitution still baffles and divides the justices of the Supreme Court, like the Establishment Clause. As Justice O'Connor put it, quote, "The meaning of these words, the Establishment Clause, has been a source of much debate, often intense and divisive, over this nation's history." The courts have struggled mightily to determine when government action constitutes an establishment of religion. Or to put it differently, what would a disestablishment of government and religion look like? Does it forbid Christmas displays or Christmas pageants? All aid to religious schools? Does it prohibit a public school from closing on the most sacred holidays during Ramadan or Yom Kippur? Does it prohibit national days of prayer? Or my favorite question, actually this was posed by comic Robin Williams, does it require us to substitute one nation under Canada for one nation under God? Beyond prohibiting the establishment of a national religion or church, there is frankly little agreement on the meaning of the Establishment Clause. It's kind of amazing to contemplate after 200 years, after hundreds of Supreme Court cases. There truly is little agreement on the meaning of the Establishment Clause among either the public or the Supreme Court. From the public's perspective, surveys show that if you ask them, 80% will agree with the statement that they believe in the separation of church and state, and even that they believe that there should be a wall between government and religion. 80%, and some go as high as 90%. But when asked about specific issues, 80% also endorsed the idea of a national day of prayer, and 70% said they wanted prayers back in public schools. Ironically, the Supreme Court in many ways is no less conflicted. After setting forth a test in 1971, a test called the Lemon Test, named for a case, not the fruit, the Supreme Court in recent years has often ignored that test, totally ignored it in Establishment Clause cases in favor of other theories. As a result, as many people put it, the court's modern Establishment Clause jurisprudence is in hopeless disarray. So if there's no settled agreement on the meaning of the Establishment Clause, what are the different possible interpretations that do exist out there? In my 15 to 20 minutes, I'd like to explore the three main approaches that the court has taken over the years and still divides the Supreme Court, the three main approaches to resolving issues under the Establishment Clause. And these can be labeled, first, the strict separationist theory, second, a neutrality or symbolic endorsement theory. Each theory has multiple names. Different people often rename it too. So first is the strict separation theory. Second is the neutrality or symbolic endorsement theory. And third is the coercion accommodation theory. And if we had to designate these theories with the popular political labels, you might associate liberal leanings towards the strict separationist approach, conservatives going more towards the third coercion accommodationist approach, and maybe moderates vacillating in between in terms of the neutrality symbolic endorsement approach. Now, before I get into each of those individually, let me just make two preliminary overview comments. First, like all constitutional interpretation, trying to determine the meaning of the Establishment Clause requires consideration of our history and intent of the framers. Unlike the Second Amendment is actually kind of unique because it gives the rule and its justification in the text of the amendment. The Second Amendment says, because a well-armed militia is essential to the security of the nation, the right of the people to bear arms shall not be infringed. Very little else of the Constitution has this kind of explanation and rule combination, and the Establishment Clause does not. It does not provide any explanation for its rule that says government shall not establish religion. So we don't have a textual explanation. And not surprisingly, the history that Steve so masterfully set forth is manipulated, claimed, malleable enough that each theorist, each different theory, claims that history for their own. They can point to some part of our history as support for their theory, as I'll point out as we go through the different theories. Suffice it to say then, the ability of each theorist, or each people justifying each of the different theories, to point to some historical proof or framers' intent to support their own particular theory and dispute the others, says as much, I think, about the malleability, as I said, and the ambiguity, to some extent, of historical evidence as it does about the meaning of the Establishment Clause. Second point in overview, my discussion of the three principles will be mainly objective as I can be. I'll outline the theories and the criticisms of each of the theories, and then give you a hint of my position, but I'm happy to elaborate upon what I believe in the question and answer session. So what are the three prevailing theories of this incredibly important provision? As I mentioned, there are three, and the first is probably the most well-known, and probably now the least embraced by the Supreme Court, and that is the strict separation theory. This theory draws on the infamous metaphor used by Thomas Jefferson that we now know from Steve, was borrowed from Roger Williams. That metaphor that the Establishment Clause creates an impenetrable wall between church and state. And this statement of Thomas Jefferson's is probably the most quoted statement in the annals of Establishment Clause jurisprudence. The idea of strict separation is that any aid to religion, even if made available equally to all religions, or in any even-handed manner, any aid to religion is impermissible. Government cannot promote, encourage, or impede religion in any way. The theory of strict separationists, as Steve points out, is based on the premise that entanglement between religion and the state harms both the state and religion. It creates religious strife, which is bad for the state, and it harms religion by encouraging government interference. And I think this is such an important point because so many of those who urge adopting a more proactive government stance towards religion accuses strict separationists of being hostile towards religion. And I think nothing can be further from the truth. The strict separation approach was embraced by the Supreme Court in its first significant Establishment Clause case in 1947, a case called Everson versus Board of Education. Justice Black's majority opinion stated, quote, "The establishment of religion clause of the First Amendment means at least this: neither can pass laws which aid one religion, aid all religions, or prefer one religion over another. Neither can the state nor the federal government openly or secretly participate in the affairs of religious organization, and vice versa." In the words of Thomas Jefferson, the clause against establishment of religion was intended to erect a wall of separation between church and state. So under a strict separation approach, a school cannot force kids to pray, nor could a city indulge in a Christmas display or a Christmas tree and menorah display, or sponsor a Christmas pageant. Even having "In God We Trust" on our money and "One Nation Under God" in our pledge in many ways violates the spirit of separation. Though this theory was the first one really embraced by the Supreme Court, as I mentioned a minute ago, it has little salience today. Currently, only Justice Ginsburg can really be identified as a strict separationist. We don't know really about Justice Sotomayor and Kagan yet, whether they would join her or take the second approach that I'm going to discuss. So why is the theory so unpopular today? There are three arguments commonly lodged against a strict separation approach. First, the argument goes that the theory does not provide a workable approach to resolving real cases. What exactly do we mean by a wall? How impenetrable is it? If totally impenetrable, some suggest the theory is unworkable. For example, would a strict separationist approach prohibit police officers, state agents, from standing guard outside a synagogue when there's a feared terrorist threat? Would it prevent providing fire service to a mosque in case of a fire? Doesn't these efforts aid religion? Because it frees the synagogue and mosque to not spend their money on private police forces or private fire departments, and to spend their money on something else. So the argument is, if it's not an absolute impenetrable wall, if you don't suggest that religious organizations have to provide for their own services this way, how do you determine when that wall can be acceptably breached? Second, some claim that the theory of separation is not consistent with the framers' intent. While the theory, as Steve pointed out, draws much support from the writings of both James Madison and Thomas Jefferson, the actual practices of Madison and other framers is claimed to be inconsistent with a wall of separation. Madison, for example, when president, issued 3 proclamations for days of fasting and approved a chaplain for the armed forces. Finally, and most important, many argue that a strict separation approach is too hostile to religion, contrary to the intent of the framers, and I'll discuss this more in a few minutes. In any event, if strict separation has these weaknesses, what are the alternatives? The second theory has numerous titles, including neutrality theory, equality theory, or the one I like to use, symbolic endorsement theory. Whatever labels attached, this is the basic idea. The central principle of the Establishment Clause is that government may not make a person's religious beliefs relevant to his or her standing in the political community by conveying a message that religion in general or a particular religion is favored or preferred. So the bottom line is, under a symbolic endorsement test, the government must be neutral towards religion. It cannot favor one religion over another or religion over non-religion. This test is most predominantly associated with Justice O'Connor, and she used the term symbolic endorsement. I think I got it. Thank you. And the idea, as I said, is a message of neutrality must be conveyed. Ironically, this theory is a little bit less concerned with what actually the effect of a law may be, with the actual effect of a law, and more concerned with how the law is perceived. So the question becomes, how do we determine how a law is perceived? And I'll get to that in a second. So under this theory, justices have held, for example, that prayers at a graduation or a high school football game was unconstitutional because they would send a message to members of the audience who are not adherents that they are outsiders, not full members of the community, and an accompanying message to those who are part of that, who are adherents to that message, that they are insiders or favored members. A state-sponsored Christmas tree and menorah together was viewed as acceptable because, according to O'Connor, these would send a message of pluralism and freedom to others. And by the way, strict separationists would find all the above to violate the Establishment Clause. So what are the criticisms of a symbolic endorsement approach? First, many argue that this approach is too amorphous and allows too much of a role for religion. As I mentioned earlier, the key question is, how do we determine how a message is perceived? What perspective do we use? Justice O'Connor suggests that we use the perspective of a reasonable person who is versed in the history and background of the activity in question. So if you're considering the constitutionality of placing the 10 Commandments in a courthouse, you would ask whether a reasonable person who knew the history behind placing the 10 Commandments would view it as an endorsement of religion. Ultimately, of course, the danger is those people who are making that decision are judges. And those judges may be, more likely than not, adherents to majority religions who are not sensitive to the feelings of outsiders. For example, People of Muslim faith may not view the display involving a Christmas tree and menorah as embracing pluralism, but may view it as an indication or feeling that they are outside the mainstream religions in the United States. A second criticism is that the symbolic endorsement theory is too hostile to religion. And to understand that, I'd like to turn to the third and final theory, the accommodationist or anti-coercion theory. This theory, I believe, represents the majority of the Supreme Court today. It is embraced firmly by Justices Scalia, Thomas, and Kennedy, and likely adhered to by Roberts and Alito. So what is this theory? It starts from the principle that government should embrace, welcome, and encourage religion. Americans are a religious people, and the Establishment Clause does not forbid government favoritism towards religion over one religion. Indeed, government should encourage religion. So what does it forbid? Two things. It forbids establishing a national church or coercing people in religious beliefs and practices. And that's it. So long as you don't engage in one of those two things, you are acting constitutionally. So, for example, school prayer for most coercionists would not be unconstitutional because no one is being legally coerced to do anything. They don't have to pray. They just have to stand silently and respectfully. A nativity scene, even a nativity scene sponsored by the government, is not coercive because if you don't want to look at it, you can turn away. You're not being forced to do or believe in anything. Up until a few years, I might add that this theory also required neutrality, that government had to be neutral towards one religion over another. But even today, that neutrality principle is in doubt. Justice Scalia, who is really the main proponent of this theory, suggests that under this coercion theory, government can favor Judeo-Christian religions. Government can favor, I'll wrap this up in a second, Judeo-Christian religions because, he said, that represents 97% of the population. And in historical evidence, our founders often referred to God. Thus, when dealing with public acknowledgement of beliefs, the Constitution permits the government, Scalia believes, to favor monotheistic religion. Obviously, this theory is criticized by people who embrace strict separationist theory as being giving way too much a role of religion, or neutrality, even neutralist theory under the same regard, for being inconsistent with the framers' intent. And you can see this by when Steve pointed out one of the bills that was rejected was an idea that the Establishment Clause only prohibited this idea of coercion. Moreover, the notion that we can favor certain religions because most of the country follows those religions is troubling, to say the least. First, Justice Scalia's 97% figures ignored those who adhered to no religion at all, which would bring it down to about 85% of the population being adherents of monotheistic religions. Second, simply because a policy only discriminates against a few has never been a reason to embrace it. If Congress passed a law providing that everyone except those of Arab ancestry could fly on airplanes, the fact that the law allows 99% of our population to fly does not save it from being so clearly contrary to our basic values and constitutional principles. So what do the disarmingly simple 16 words of the First Amendment mean? I hope that my presentation at least arms you with an understanding of the three main theories that have been employed by the Supreme Court. As I mentioned, the third one, the coercion theory, is now likely constitutes the majority of the court. And this, to my mind, is an unfortunate circumstance. As so much of the world struggles with religious strife, it is my belief that our greatest strength has been preserving, as much as possible, a wall between church and state. Justice O'Connor put it most persuasively when she said, "At a time when we see around the world the violent consequences of the assumption of religious authority by government, Americans may count themselves fortunate. Our regard for constitutional boundaries have protected us from similar travails, while allowing private religious exercise to flourish. Those who wouldn't renegotiate the boundaries between church and state, like the coercionist theory, must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly?" Thank you.